Trena R. Jefferson et al. Versus Patricia A. Williams, Mapp.
Ms. Williams, if you'd come up to the podium, please. Ms. Williams, when we begin, one of the first things I want you to do is to state your name because all this is being recorded. So we'll know who you are. We know who you are, but we need you to state your name in any event. You'll get 15 minutes to make your oral argument. In other words, 15 minutes to tell us what you want us to know about this case. You may reserve up to 5 minutes of that 15 minutes as rebuttal time. What that means is the other side will have 15 minutes after you complete your argument. If you want to, you can reserve 5 of your 15 minutes to come back and rebut what the other side has to say. Would you like to reserve any rebuttal time?
Yes.
All right, and how many minutes? You don't have to reserve 5. You can reserve anything up to 5.
5 minutes.
Okay. All right. I understand you're representing yourself and you're not an attorney. Do you have any questions about any of the procedure here before we get started?
No, sir.
All right. All right. If you would then just tell us who you are and just you go ahead and tell us what you want us to know.
Okay.
Those lights on that monitor, it will go green, yellow, red. And when we get to red, that means you've used up your initial 10 minutes, okay?
Okay.
All right. All right, Ms. Angie. And you may proceed, ma'am.
Good afternoon, Your Honor. My name is Patricia A. Williams Mapp. I am a graduate from with a BA degree. I have a paralegal certificate, and I have 1.5 years of law school. I have had a stroke in 2005, and I wish that the court spared me a little leniency with the speech. I am presently in Asia, Baptist Study, and Memphis State on the speech.
Ms. Williams, if I could get you to pull that microphone down just a little bit there. Okay, that's good. Thank you, ma'am.
Okay. I've set aside 5 minutes for rebuttal. The appeal is based on why I haven't received a fair trial at the trial court level. The reason I said I didn't receive a fair trial at the trial court level because I had 2 witnesses to testify about a matter fact that they were witness while being on the defendant's table, which is Trena R. Jefferson, who stated during a family conversation that she would repay money that is in question or dispute. Table of contents is with Trena R. Jefferson et al. Versus Patricia A. Williams, Volume 1. September the 11th, 2020 is the response of declaratory judgment and failure relief. Number 2, 7/21/2021, subpoena return served on Michael Williams. 7/21/2021, subpoena return served on Reverend Pearl L. Lurie. 9/14/20, affidavit of Michael Williams. 9/14/2021, affidavit of Patricia A. Williams Mapp. 9/28/2021, affidavit of Michael Williams to appellate court clerk office, which was a concise statement. The Honorable Judge Court error when appellant witness was not allowed to testify during the process of the hearing at the summary judgment hearing, causing appellant an constitutional violation of the United States of America Constitution and the great state of Tennessee Constitution, where it is written that all persons shall be heard and shall have the right to present witnesses on one's behalf. Thank you. I'll save the rest of my time for
Okay.
rebuttal.
All right, we'll, okay. Thank you, ma'am.
All right. Thank you.
Hear from the appellee.
Good afternoon, Your Honors, and may it please the Court. My name is Laura English, and I am the attorney representing the appellees Trena R. Jefferson and James W. Jefferson, Jr. Your Honor, the issue presented before the Court today is whether the trial court properly granted the appellee's request for motion for summary judgment in this matter. The appellant's argument that she was denied a fair opportunity in the trial court because her witnesses were not permitted to testify is incorrect for the following reasons. First of all, a motion for summary judgment is just that. It is a motion hearing on a legal issue when there is no genuine issue of material fact. The original petition in this matter was filed in August of 2020. Ms. Williams Mapp then proceeded to file her response to the petition in September of 2020. The motion for summary judgment was subsequently filed in October of 2020, as the response filed by the appellant did not dispute the key issue upon which the original petition was filed, and that is this. Ms. Williams Mapp has filed a lien in the Shelby County Register's office against my client's property. That lien is improper and illegal. The petition for declaratory judgment is simply asking for the court to void that lien, as it does not comply with the statutory requirements necessary to file what is called a lien lis pendens. It's undisputed by Ms. Williams Mapp that she does not have a judgment against my client for any sum of money. Therefore, she is not a judgment creditor that's entitled to place a lien on their property for execution pursuant to Rule 69.07 of the Tennessee Rules of Civil Procedure. Therefore, her only remedy is to file what is referred to as a lien lis pendens. Statutorily, in order to do that, she must first file an abstract that has been certified by the clerk of the court that properly describes the property that is subject to a bill of suit or a complaint that has been filed subject that the property in question is subject. No such action has ever been filed by Ms. Williams Mapp against my client. It's undisputed. That's the only fact that's relevant. My clients are not without sympathy to the issues that Ms. Williams Mapp would like for the court to address, but those are not relevant to the action that are filed. In her response to the complaint, the original complaint, and in her response to the summary judgment, she admits she does not have a suit against my client. She's never sued them in any court, in any state in the United States of America. She has no judgment. The requirements simply are not met. What she filed with the registrar's office was not a certified abstract of certified abstract that describes the property in question. She didn't meet the statutory requirements. It's that simple. And that's what the motion for summary judgment was based upon. That was why it was filed. It's not proper for witnesses to testify at a motion for summary judgment hearing. The case was pending for over a year as the Honorable Chancellor Evans had retired and we awaited a reappointment to replace him. During that time, Ms. Williams-Mapp did not issue any discovery to my clients. She did not subpoena any witnesses to sit for a deposition, which she had the right and the opportunity to do. She did submit affidavits in her response to the summary judgment. Those were considered by the court. But again, the issues about which she wanted them to testify are not related to the issues that were present before the court, and that's whether or not she had properly complied with the statutory requirements.
You have asserted, at least in your initial complaint, 2 additional theories as to why the alleged lien should be invalidated. Have you abandoned those claims?
Yes, Your Honor, we dismissed those at the summary judgment hearing, and we proceeded only on the fact that the lien that had been filed and registered with the Shelby County Registers of Deeds did not comport with the statutory requirements. So we voluntarily abandoned our claim for slander of title.
Also, in your complaint for declaratory judgment, you had requested attorney's fees. Trial court did not rule on that request. Have you abandoned that request as well?
Yes, Your Honor, we did. We withdrew our request for attorney's fees.
Okay. All right. Thank you.
Thank you. If the court has no further questions, then I would just ask that the court affirm the ruling of the trial court in its entirety. Thank you.
Thank you. Ma'am, you have your rebuttal time.
The reason why I am here, Your Honor, I've been fighting my case since, and you can see, since 2020, and have it in document. I also asked the defendant, why is my daughter not to mess up with the trust account? And to wake up and it's gone, it hurts. I'm 70 years old. I should have been and should have received that money. I would ask the court if he could give me the property, the lien on the property. Thank you.
Thank you, ma'am. The court will take this matter under advisement and will issue an opinion at the earliest possible time. We appreciate your argument. We will stand in recess to the call of the next case.